Welcome to the Legal Lowdown. I'm your host, Matthew R. Carpenter, an attorney, and today I am looking into the latest SEC enforcement actions. We're unpacking some recent cases leading into the week of July 28, 2025, and I'm super excited about this episode because this will get me all caught up on SEC enforcement actions. Okay, so last week we had cases involving unregistered brokers, shady Ponzi schemes, some sloppy insider trading, and just outright robust financial fraud and misappropriation. And by the way, why do I do this, you might ask? Well, first, I like to stay informed, but perhaps more important than that, I think connecting the dots on these cases kind of shows how this stuff happens, and if possible, it might just end up saving you or someone you love one day. So I think it's pretty important. So let's start with the folks who try to, get in the game without proper credentials, like trying to play in the NBA without earning your draft spot. In the SEC world, though, it's usually someone building a whole business that's just based on smoke and mirrors. Anyway, insider trading. That's what I'm getting at. That's what I'm alluding to. Let's start with SEC versus Old South Trading Co. LLC in the Southern District of California. In that case, you got a father and a son, Brendan and Chuck Church. They allegedly raised about $26 million from 100 investors by selling unregistered notes. And crucially, neither of them were registered brokers, which means they sold the securities illegally. Some of the investors cashed in their securities and were paid back the value they invested, but the operation fell apart, and I think something like 79 investors are still owed around $11.6 million. The SEC brought claims against the defendants under Securities Act Section 5A, which basically prohibits the sale of unregistered securities, which usually happens when a security is sold without filing a proper registration form for it. And the SEC also sued the defendants under Exchange Act Section 15A, which makes it illegal for anyone to sell securities without first being registered to do so themselves. So you have to register securities and you have to register yourself if you're a securities broker. And in the end, the defendants basically settled. They got hit with permanent injunctions, which always happens in these cases for the most part, which means they're barred from selling securities, and it's basically game over for them in the securities world. Oh, and they have to pay nearly $500,000 in penalties. These securities cases are kind of wild, though, because there's roughly $11 million still owed to these investors, and yet the defendants only ended up paying $500,000 in penalties and only $15,000 in disgorgement, which is really what's supposed to go back to the victims, right? It's kind of crazy to me. Next, we have offerings fraud cases, which is kind of like selling unregistered securities. With unregistered securities, you're selling something that should not be sold or something you are not authorized to sell. In offerings fraud cases, something may be eligible for sale and you may be authorized to sell it, but you lied to get people to buy it. And sometimes those lies can be about the security's value, or in many cases, as we've seen, those lies can be about your reputation. And that's what happened in our next case, SEC versus Guess from the District of Nebraska. In that one, the defendant, who was already a felon, made misrepresentations to about 60 people across 12 different states, and also to one foreign country. This dude was, aiming for the moon. He did all that to raise money for a fake investment firm. The defendant told the investors the firm would invest in energy, healthcare, tech, and real estate, but really the firm didn't do much of anything at all. Even though he said the firm was projected to make millions, it only brought in about $15,000 from 2019 to 2022 because he ended up selling a couple computers. The SEC got involved and brought Securities Act Section 17A claims, which penalize people who use fraud or deceptive practices to offer or sell securities. Apparently, in this case, the defendant is on the run and he never appeared. So a default judgment was entered and a penalty of $15,000 has been imposed. Now, remember how I said unregistered securities cases and offerings fraud cases are similar? Well, even though this is a offerings fraud case, this guy could have been hit with unregistered securities claims under Section 5A, under Securities Act Section 5A, and Exchange Act Section 15A because he sold securities without proper registration. Okay, so continuing on from unregistered players and offering fraudsters, let's talk about the classic Ponzi schemes. Robbing Peter to pay Paul. These schemes are built on trust, but it's misplaced trust. And that promise that just sounds, way too good to be true, often comes with pressure to get in now. And to better understand what I mean, let's look at SEC versus Frost in the Northern District of Georgia. The defendant, Edwin Frost, and his firm, First Liberty Building and Loan, allegedly ran a Ponzi scheme for over 11 years. Just think about that. 11 years of scamming. Man, that's dedication. And throughout that 11-year process, he defrauded about 300 investors, or at least 140 million. Investors thought their money was going into specific financial instruments, but it wasn't. Portions were just misappropriated. As is often the case, the money was used to pay early investors. That's the Ponzi scheme part. But the money also went to the defendant's personal use. In the end, the SEC brought Securities Act Section 17A claims and Exchange Act Section 10B claims, and the defendant settled. He consented to permanent injunctions, and the commission seemingly got much of what it wanted in that one. Before I move on to the next bucket of cases, we do have another Ponzi scheme. This one is in a case titled SEC versus Lickis, recently filed in the Northern District of California. Over the span of 6 years, defendant Lickis sold securities to about 80 investors, but the problem is that Lickis had been suspended from registering as a securities broker. That suspension was in effect from 1987 to 2014, where some of this illicit activity was happening. And just taking a step back for a second, bruh, what did you do to get suspended for that long? Oh yeah, he allegedly failed to disclose tax liens, so he wasn't paying people, and the IRS put a lien on his property, and he refused to disclose that to folk who need to know. And by way of his Ponzi scheme, he was able to induce investors in this Ponzi scheme through the most classic method ever, by pitching huge returns, right? Of course. The SEC ended up suing him for Securities Act Section 17A and Exchange Act Section 10B claims. The U.S. attorney has also filed a parallel criminal action. That case is still ongoing. So it just shows you, right? You can get hit with civil penalties, you can get hit with criminal penalties, and there's a lot of risk that comes with securities fraud, right? Securities trading, if you don't know what you're doing. So let's shift gears for a second. Insider trading, the stuff that everybody loves to talk about, getting that inside scoop before anyone else and using it to cash in. It fundamentally breaks the idea of a fair market when you really think about it. It's like playing poker, but already knowing what everyone else has in their hand. Totally unfair. And that's what happened in our next case, SEC versus Thompson from the Eastern District of Virginia. In that case, defendant Thompson basically just used his inside banking knowledge to scam the market. He worked for a branch of the Federal Reserve in Richmond, Virginia, where he supervised banks. But back in 2024, though, he learned that one of the banks under his supervision was about to announce very good earnings. So what did he do? He bought nearly $700,000 of that bank's stock. Around that same time, he knew another bank was about to announce poor financials, so he sold his stock and profited nearly $600,000 off that transaction. First of all, I didn't know Federal Reserve Bank supervisors were rocking like that. I didn't know they had bread like that. And second, he must not have been too smart, because defendant Thompson was caught and hit with the Exchange Act Section 10B claims, and he is also hit with a criminal action too. He settled and agreed to pay $65,000 in disgorgement and $65,000 in prejudgment interest. So, I called him not that smart, but when you think about it, he made hundreds of thousands and got off after paying only $130,000. He probably lost his job too, but dang. And for some of y'all in the streets, I think you're in the wrong business. Anyway, carrying on. Our next case is SEC versus Cashman in Arizona District Court. This one's interesting. Defendant Cashman apparently got tipped off, and this is an insider trading case. He apparently got tipped off by a friend who worked at Knight Swift about a confidential deal negotiation. Apparently, Knight Swift was about to buy a company called U.S. Express, which would make U.S. Express's stock soar. So after this confidential conversation, literally the next day, defendant Cashman sells off a mutual fund that he has and buys over 18,000 shares of U.S. Express. The deal gets announced and boom, share prices jump almost 300%. The SEC found out and brought Exchange Act Section 10B claims. Defendant Cashman settled, and he had to pay back the profits, some interest, and a penalty, all of which totaled over $160,000. Okay, our last category, just outright deception and misappropriation, where the foundation of trust, financial reporting, is gone. These cases hammer home the importance of due diligence and, just basic skepticism, right? Keeping that side eye when it comes down to money. When the receipts look fake or the story sounds too big, all cap, no facts. Your BS radar antennas need to be way up. not just in the dating world, but in the finance world too, people. Okay, let's look at SEC versus Matthias, which is a case in DC federal court. Defendant Matthias, through his firm American Metro Inc., made totally false SEC filings. I think defendant Matthias owned land development companies, and his SEC filings claimed that a subsidiary associated with one of his companies had landed a huge $500 million contract in Cali that defendant Matthias's company would profit from. Another fake SEC filing said that a company associated with defendant Matthias acquired $1 billion real estate business, and that the deal was backed by more than $950 billion raised from wealthy international investors. So, like, this dude was making all the lofty claims. He making all the claims. And the case is still fresh, but the SEC brought Exchange Act Section 10B claims and Securities Act Section 17A claims against defendant Matthias. In our last case, we have SEC versus D'Ambrosio from the Southern District of New York. And it's just kind of like a sad, straight-up betrayal. Long story short, defendant D'Ambrosio created an investment company for family and friends. They basically just siphoned their money through it and tried to cover it up with fake financials. D'Ambrosio misappropriated the money and the company ran out of funds. And when that happened, he just basically self-reported to the government. The SEC then filed a complaint alleging Section 206 claims from the Investment Advisors Act, and D'Ambrosio settled and agreed to injunctions. Penalties and other financial sanctions are currently being considered. Okay, so wrapping this up, we've seen unregistered players, Ponzi schemes, insider trading, outright fraud, and just misappropriation and family betrayals. Dang, y'all, come on. It's summertime. Don't got nothing better to do. Well, anyway, you tell me, people, do you think you can really spot these red flags, right? Especially when you hear those all-cap, no-fact promises flying around. And maybe in a world where information just moves incredibly fast, like, what's your strategy? I'm curious how y'all feel after hearing all this. You know, are you going to be more trusting with people or less? Leave your thoughts in the comments below. And thank you for tuning in to this episode of The Legal Lowdown.